Hi folks, this is a re-upload of a video that I uploaded yesterday. In my haste, I ended up using an incorrect image of the offender. Now, I'm not going to apologise to the offender because the offender whose image I used is a cretin anyway and doesn't deserve an apology. But you guys, being my subscribers and my viewers, do deserve an apology. I was in a rush and I used an image without triple checking it. So for that, I apologise. This is the amended and re-edited version of that video. So it's nice to see that some judges see child abusers as what they are, pieces of shit, rather than simply just somebody to do picture swapsies with, allegedly. 20-year-old, I don't even know how to pronounce that, so I'm not going to bother, pleaded guilty to 3 counts of rape of a child under 13 at Inner London Crown Court in June 2021. However, the judge at the time thought that a 3-year community order, which required him to do 200 hours of unpaid work, 40 hours of rehabilitation activity, and 48 sessions of choices and change programme, was an appropriate deterrent for him. Not even a suspended sentence for admitting 3 counts of rape to a 12-year-old. How fucked up is that? However, the sentence was later reviewed after Solicitor General Alex Chalk QC took it to the Court of Appeal, arguing that it was unduly lenient. When Mascall met his victim, it said that she told him she was 20 years old, had a car and her own home. Now, I get that some children may look a bit older, okay, can look a little bit older, but by 7 years, a 12-year-old looking basically 20. I find that very hard to believe. The original sentencing judge said she found, so it was a woman judge, she found that there had been no grooming of the victim. There was an absence of exploitation and that his belief around her age was reasonable, adding that Mascall was a young man who is relatively ordinary, immature and possibly rather naive. Naive? You'd have to be fucking blind, not naive. The Court of Appeal judges did rule that the victim may have passed herself off as a 20-year-old, but that it didn't detract from her vulnerability. They said that there were significant aggravating factors in the case, such as the location of the offending, although there is no mention of where the offence took place. They concluded the Crown Court judge's sentence gave insufficient weight to the nature of the offender's culpability and the aggravating features involved in his conduct towards the victim. In their ruling on Monday, Court of Appeal judges agreed the initial sentence was unduly lenient and replaced it with a custodial term of 36 months in a young offenders institute with a further licence period of 1 year. Mascall must serve at least 1/2 of his custodial term before being eligible to apply for parole. Mr. Chalk QC said after the ruling, Mascall's actions have harmed the victim and her family, and his naivety and immaturity are no excuse. I welcome the increase today, reflecting the seriousness of his actions. How the hell can any Crown Court judge, we're not talking a magistrate's judge here who gets advice from somebody else because they don't know the law, but a Crown Court judge who is supposed to understand and know the law, how can they give somebody a community order for 3 guilty rape verdicts, or guilty of rape times 3 of a 12-year-old? Big thank you to channel supporters, especially these guys. Your support is truly appreciated. Don't forget to like, share, comment and subscribe. Let me know your thoughts, as I know many of you will. And until next time, stay safe, look after each other, film the police and other officials.